We are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. And today we're going to talk about what I have labeled maybe the most important case, most significant in crypto. And that is the Caitlin Long battle that she has with Custodial Bank against the Fed. We're going to talk about that. Now, all the cases are important. Listen, the XRP Ripple case, obviously I got involved in that in the beginning, huge, and the victory was huge. The Grayscale victory, huge. The Coinbase case pending now, huge. But why do I say that this Caitlin Long Custodial Bank battle could possibly be the most important or significant case in crypto? Because listen, everybody, we're not going to go to a all crypto 24/7 mass adoption. You have to have the banks. You have to have on ramps and off ramps, and you have to have banks that can bridge that gap. And Custodial Bank is one of those. And so let me bring on my guest, Caitlin Long, and welcome her to the show.
Hey there. Thanks, John, for having me on.
No, thank you so much for being on. I meant everything I said about what you're doing and the battle that you're engaged in. And obviously, I'm only going to talk about stuff with you that's public record. I know that you can't comment on many things. I wish you could, but
correct.
I know that I'm a lawyer. You're a lawyer. We're going to respect that, of course. But first, just tell us, why are you a founder of Custodial Bank? And then we'll get into what Custodial Bank is real quick, because some of the people might not know.
Yeah, well, it really comes down to ensuring that there is a durable on-off ramp for US dollars and digital assets. And that is the basic problem that the state of Wyoming set about to solve when it created this new bank charter in 2018. It became live in 2019. There were a number of entrepreneurs who testified at the Wyoming legislature in the 2018 legislative session that their banks closed their bank accounts and the startups literally disappeared, because in the United States, you're not an operating business if you don't have a bank account, because you have to remit your payroll taxes to the IRS through a bank account and electronically. And so a lot of startups hit the wall. And that's what the Wyoming legislature back then thought was the opportunity, was let's create a durable on-off ramp by creating a special type of charter to service this industry. And boy, has it been a winding path ever since then. I also want to just to correct the record, I am trained as an attorney, but I've never actually practiced. I'm a dormant member of the New York Bar.
All right. Well, thank you. Basically, what's the mission of Custodial Bank?
Well, the mission is to provide a bridge between the traditional US dollar system and the digital asset system, specifically Bitcoin. That's what we're starting with.
Right.
And to do it in a regulatory compliant way, and to do it in a manner where neither the new nor the old system hurts each other. And we saw both sides, both the new and old systems, hurt each other in 2022. We saw the traditional banks cutting off the startups, the legitimate law-abiding ones, and of course the scammers and criminals. They just threw the baby out with the bathwater. And we also saw that problems with this industry, particularly the fraud at FTX, that hit 11 FDIC-insured banks that were clearing wires meant for FTX that ended up going into Alameda. And if you read the FDIC Inspector General reports, they identified there were 11 US banks that were caught up in that. And if you then cross-reference it to the FTX bankruptcy filing, it's pretty clear which 11 banks they were talking about, 2 of which were GSIBs, the global systemically important banks. So that tells you that that frankly, by keeping these two ecosystems as separated as they have been from a regulatory perspective, all that's happened is they've hurt each other and not the other way around.
And so for my audience, you may be aware that a lot of the people watching and follow me is because of the Ripple XRP case. the XRP community is a very significant part of the people that follow me, that watch Crypto Law TV. And I want them to understand how important what we're talking about. There is a company, it's called Spin the Bits, and it's to spend your Bitcoin. It's a payment app, and the person that founded it uses it, basically the XRP ledger, as a layer 2 solution, sort of like in competition to Lightning, if you will, where you can spend your Bitcoin in seconds, and you don't got to wait for the 10 minutes or the hour. But speaking to the founder, he could have the greatest technology in the world, but if he can't get a bank account, and if he can't have access to US dollar or the Canadian dollar or whatever, it doesn't matter how great his tech is. And that's where I think we've seen the government, unfortunately, attack crypto. And I won't get in that with you, but can you explain, then we're going to talk about this decision that came down last year from the judge in your case, where you were able to survive a motion to dismiss and actually start discovery against the federal board and the Federal Reserve Bank of Kansas City. What is a master account? Because we're going to talk about that.
Yeah, a master account is a bank account for banks. It's essentially an account for those who are eligible to bank at the Fed. And federal law defines 2 categories of entities that are eligible to bank directly at the Fed. One is insured depository institutions. Another is depository institutions that are eligible to apply to become insured. And I think we know that the FDIC, which started Operation Choke Point almost 10 years ago, we do know, I don't even have to say, I think we do know that the FDIC was not interested in touching the digital asset industry. And for a very specific reason, I actually agreed with that decision, because most of the banks in the United States don't have the ability to come remotely close to real-time settlement from an IT perspective. And so it was just too risky for the FDIC to let FDIC insured banks handle these fast settling customers, right? The digital asset industry, data moves at the speed of light. It settles it within minutes with finality, with irreversibility, right? It's pretty obvious that a traditional bank that can only update its books and records once a day might get into trouble pretty fast if they don't have the right IT capabilities, right? So, but that said, that second category of depository institutions that are eligible to apply to become insured, so they technically don't even have to apply. Custodia did and was told 18 ways from Sunday we weren't going to get FDIC insurance. Not a shock. We didn't fight that. But that second category, which is uninsured depository institutions, that is where, under federal law, it's crystal clear the Federal Reserve must provide services to eligible depository institutions, including those that are uninsured but eligible to apply to become insured.
All right, great. What we're going to do now is I came across this. Obviously, it's public record. It'll be on Crypto Law. It is the judge's decision, order on defendant's motion to dismiss amended complaint. And I recommend everyone to read this decision if you're interested. And I noticed right off the bat that Senator Patrick Toomey had filed an amicus brief, former senator.
Correct.
Toomey and the state of Wyoming. And basically, the judge goes through the background, but he basically says that you applied for the master account and you were denied. And then you have filed a case where you're alleging a couple of things. One is a writ of mandamus that's going against the Federal Bank of Reserve, Kansas City, and also under the APA, basically a claim against the Federal Board of Directors. Is that
Board
accurate?
of Governors, Federal Reserve Board of Governors. That's the DC agency that sits on top of the 12 regional reserve banks, of which Kansas City is the regional reserve bank for Wyoming. Yes.
All right. And the judge's decision lays it out. He's in August 2021, Custodia applied for that membership.
August 2020. It actually, yeah.
Oh, okay.
Sorry. So October 2020 is when we applied to become a member bank. Yeah.
And then I'm reading.
No, sorry. October 2020 is when we applied for a master account. We applied to become a member bank in August 2021. Sorry about that.
Perfect. And he lays out that on January 27th, 2023, the Board of Governors denied Custodia's application for membership into the Federal Reserve. And a few hours later, the Federal Reserve Bank of Kansas City denied Custodial's master account application. I'm not going to ask you to comment on the coincidence of a few hours, of course, but I found that the judge made that clear, speaks volumes in certain ways. The Federal Reserve Bank of Kansas City's denial came 27 months after Custodio had applied for a master account, even though the master account application notes that it should be in 5 to 7 business days. And so basically, Custodio has sued, basically saying that you were supposed to give me a master account because the statute says shall, it's my understanding, and you failed to do so, and therefore we're moving forward in a case. I want to talk about how often does the federal, either the Kansas City Federal Reserve or the Board of Governors, have they been sued in the last decade?
Not often. In fact, actually, I think you're making reference to the Market Watch article, which cited a law review paper by David Zering, a professor at Wharton, who commented that the Federal Reserve is almost never sued. And his data showed that there were 2 lawsuits by banks in the entire decade, 2010 to 2020, against the Federal Reserve. And one was over the constitutionality of the CFPB, the Consumer Financial Protection Bureau. But so really there was only one comparable lawsuit. And at the moment, there are 3 lawsuits over the same statutory question. And I understand others are coming as well. So that tells you something has changed.
And could you just summarize what the statutory question is, just so everyone else?
It pertains to the word shall. If you look back at let's look at the history. The Federal Reserve was created in 1913, and the Federal Reserve Act has been in place since then, amended multiple times. Then there was a big amendment in 1980 under the Monetary Control Act of 1980. And that is the statutory language at issue. I would refer you back to the public documents. Right. And the question is whether the Federal Reserve shall provide services to all eligible depository institutions. The legislative history, as I've spoken about before, is very interesting there. Paul Volcker, who was in charge of the Fed when that bill got passed, it was passed early during his Fed chairmanship. What he was doing at the time was literally begging Congress to require all depository institutions in the United States to be on a level playing field. They were not on a level playing field back then. The thrifts had certain advantages over traditional banks. And when the Monetary Control Act of 1980, which has that shall language, was passed into law, the Federal Reserve went from serving 5,000 depository institutions to 40,000 depository institutions overnight. The idea, again, was to create the level playing field. And it was the Fed itself that was actively seeking the language that required all depository institutions to be serviced equally.
Right. It benefited the Fed at that point in time.
It certainly did, yes.
Right. Now, the judge, again, I want people to read this decision because the judge, and I'm reading directly from his language, he explains that basically a master account, put simply, is a bank account for banks that gives deposit institutions access to the Federal Reserve's systems services, including its electronic payment systems. And the judge goes on to say that without this account, basically, you're just a depositor and withdrawal. You're limited to deposits and withdrawals. Is that fair?
Yeah, you're essentially a vault if you can't plug into, FedWire and ACH. So now now you start to kind of see why this is a broader issue than just the digital asset industry. There are 3 cases, as I mentioned, in flight right now over that same statutory question, only one of which touches digital assets, and that's Custodia. The other 2 have nothing to do with digital assets. But it gets back to the raison d'etre that you asked me about in the beginning. What is Custodia trying to do? It's trying to create a durable on-off ramp where we're specializing as a bank in the particular risks of the digital asset customer base. And we saw that. And we knew, by the way, Custodia knew that there was heightened bank run risk for traditional banks that were serving the digital asset industry because of how fast settling and how high velocity the transactions in this asset class can be. I mean, heck, stable coins at one point, each tether was changing hands 3 times a day.
Wow.
Okay. The monetary velocity, the M1 velocity of the US dollar is 1.2 times a year versus
Wow.
3 times a day. Okay. So you're in a different zip code. There's definitely different operational and liquidity risks. And Custodia was, and frankly, the whole Wyoming Special Purpose Depository Institution Charter was designed to take those issues head on in a risk mitigated fashion, because Wyoming Speedy Banks can't lend. Okay, so our proposal at Custodia to the Fed was to hold $1.08 for every dollar of demand deposits, US dollar demand deposits,
Wow.
at the Fed itself.
That's revolutionary.
Well, right, but just to give you an illustration of how different that is, Silvergate was holding 10 cents of cash for every dollar of deposits, and Custodia was proposing to hold $1.08 of cash for every dollar of deposits. Big difference.
Oh my God. People need to understand that if you have 1 to 108, right? You can never have a bank run because it's there.
Well, you could have a bank run, but the point is the bank survives it and cashes all the customers out.
Yeah,
right?
you're right. Yes.
That's the point, right?
And the point is, if you have a bank run, you can satisfy all of the withdrawals 24/7.
That's absolutely correct. The liquidity risk in this business model is vastly different than the liquidity risk of a traditional bank. That, again, in this case of Silvergate, it was pretty obvious. If you looked at their balance sheet, you go back and look at Silvergate or Signature's balance sheets, it's pretty obvious that they had massive bank run risk, 6-9 months before, because they were investing in term securities that had, and we saw this in Silicon Valley Bank as well, long-term treasuries. Okay. And unfortunately, because of the rise in interest rates, all of those are underwater. And so if they had to liquidate those very quickly, then the solvency of the bank became impaired due to the liquidity issue. The whole purpose of the Wyoming Special Purpose Depository Institution Charter was to acknowledge that you really can't combine traditional lending with a fast settling demand deposit. That is just inherently unstable, and you're going to have bank runs where the banks fail. And so the prudent way to approach this is to say to the banks, you're not lending and you're not investing in term assets. And it's public information. Custodia has 100% of our investments in T-bills of 3 months or less.
Okay. And listen, now we can understand maybe. Well, again, I'm not going to get into editorializing with you because I know you're in the middle of litigation and whatnot. We could stick to the public record. But what people need to understand why this is so important, what I was thinking about, Caitlin, is on one hand, like if you take the Ripple case or you take the Coinbase case, you're talking about the underlying asset and you're talking about token issuers and whatnot. But when we're talking about your fight, you're talking about users, developers, companies that need access, to be able to pay their employees in US dollar or whatever the matter might be. And they need to have that electronic payment system, settlement services, everything that you're trying to get once you get a master account. And so I think that's why I just want to keep reminding people why this is so important, because users versus maybe token issuers is one way to segregate the importance of these cases. They're all important, like I said.
Well, you and I have chatted in the past, John. If I could ask you a question.
Yeah, absolutely.
The SEC cases are so interesting because they are about token issuance. And your point is, not all of them, but many of them, token issuance, and are they securities, whether at the point of distribution or whether in secondary markets. But the Custodia case is about something much more foundational, to your point, which is, can a business even survive if it doesn't have US dollar access in the United States to be able to pay its vendors and very importantly, to be able to pay the IRS its withholding taxes, as we talked about earlier. right? And so a lot of the startups in the industry might be looking at the SEC for clues as to whether their project is going to be deemed a security or not. But they won't even get off the ground if they can't get a bank account, or like the Wyoming legislature heard testimony in 2017, 2018. They might hit a wall as a startup if their bank closes their bank account and they don't quickly have a backup. And one of the things that has happened with this Operation Choke Point 2.0 that has happened in 2023 under the Biden administration is a lot of startups have had their bank accounts closed. There are major crypto companies in the United States that are operating with only one bank account, and there's a proverbial sword of Damocles hanging over their heads, because if that bank closes their bank account, then where are they going to go, right? And so there are a number of people who've been identifying this as a foundational issue for the industry, but I'm really glad you picked it up from the legal perspective. And what I'm pointing to is Ryan Selkis at Masari has been saying this for years. This is a single point of failure exposure. If we don't keep our US dollar on-off ramps for the legitimate companies in the United States in this industry. And then most recently, I was reading Lynn Alden's book, Broken Money. And the first risk she pointed to isn't banning crypto. It's closing off the on-off ramps as the risk. Yeah.
100%. Listen, certain banks that I deal with, personally and business wise for my law firm or whatnot, a couple of my banks, you can't sign up with Coinbase, or you can't sign up with an Uphold or any other type of exchange. And certain banks have already taken the position with your money, with my money, right? That I'm willing to risk. They're not going to allow me to have that. I can't link it to Coinbase or something like that. And so we're already seeing a lot of banks. And one of my banks used to, and then they stopped probably about a year ago.
There's a very interesting article from Professor Julie Hill, who's been following this very issue and has written a law review article about it. She's also become a specialist in marijuana banking, and she just recently wrote an article about the Safe Banking Act, which is going through Congress right now, where she said it's really not going to change much, because federally the banks are allowed to bank with marijuana companies if the Safe Banking Act becomes law. But her point is that the compliance costs are so high that the vast majority of banks won't do it. And John, that's why a lot of banks, they're getting pressure from the regulators behind the scenes, no doubt, but they're also saying, if we don't, basically you can't dabble in a high risk business. That's the way the bank regulatory regime works. And so that's why Julie Hill was saying she didn't think that this was going to change the marijuana banking landscape very much, because very few banks want to build the compliance expertise to bank that particular high risk industry. And the same is true of the digital asset industry. And as we lose more and more and more of those banks, it starts to become literally a choke point. That there was a really interesting article in Bitcoin Magazine released yesterday where they go through the history of how Operation Choke Point 1.0 got its name. The choke point is the on-off ramp, and that, to Lynn Alden's point, that's actually the bigger risk than the government trying to ban it, right? The government's learned in Napster you can't ban code, but you can choke the on-off ramps, and that's
absolutely. And the judge cites one of the paragraphs in an amended complaint that says, without a master account, if Custodia is able to operate at all, it is as a second-class citizen relegated to dependency on a fealty to an intermediate bank, which does have a master account. And the whole purpose is to eliminate that friction where you would have to rely on an intermediary and fees are higher to the end user. And my understanding is you're trying to eliminate all that and provide better, more secure services to your depositors.
Yes, we're trying to partner with banks. We just announced an announcement today. Lisa Huff from the energy industry in Houston joined us to work with Bitcoin companies and energy companies for their unique banking and Bitcoin custody needs, especially as the Texas companies, but it's all over the United States, the Bitcoin miners, the interruptible processing demand for power, they're starting to become integrated into the risk management of of public utilities and other energy companies. You know, we want to partner with the banks. Those energy companies already have bank relationships, but what those banks don't have is the specialty in digital assets and the ability to custody Bitcoin. So we want to partner with those banks, absolutely, and we will, because thankfully we have good partners already who are actively saying, look, this technology is not going away. We want to work with the white shoe version that is not going to burn its reputation by banking FTX and, you know, making the mistake that those 11 banks did, that were letting wires that customers thought they were sending to FTX go into Alameda's account. That is a huge no-no. Every one of those 11 banks should have caught that, and apparently none did. And so that kind of stuff, though, I mean, Custodia is a real stickler, I will say, where, by the way, our deposits are not FDIC insured, and we're not licensed to operate in all states. I want to make that clear. Refer to our website for an update on where we are operating. But I think this second generation of intermediaries is going to have a very strong incentive, including Custodia, to keep the chaff out and only let the wheat in, so to speak. Really, to work with the true law-abiding, above board customers, and not to try to reach to service the FTXs that were not regulated, that were offshore, that didn't even have a board, things like that. All kinds of red flags. They shouldn't have been onboarded to the banks that they were onboarded to, but 11 U.S. banks clearly did and got stung by that. So I think that this next generation of intermediaries, and there are new ones coming, are really truly going to stay white shoe and above board.
All right, thank you. Listen, what the audience needs to know is that there was a motion to dismiss filed by the defendants, and the judge came back with a decision. And here's what has survived. In this first claim, it is asserted, Custodia asserts that only against the Board of Governors under the Administrative Procedure Act, and alleges that the Board of Governors agency's action in denying Custodial's master account was arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. And we've all heard this arbitrary and capricious language that came down, obviously, in the Grayscale case. But that's the one, that claim survived. Am I right?
I'll refer you to the public documents.
Okay. All right. No. Sorry if I'm putting
that's all good.
So I'm going to make sure everybody knows that I'm reading from the judge's decision, which is public. Custodial's second claim is asserted against both defendants. It seeks a writ of mandamus. And, writs of mandamus are very special to me because I filed arguably the most bizarre writ of mandamus in history. There it is, an actual picture of when I was writing it, when I filed the writ of mandamus against the SEC. And so, and then finally, the final claim seeks a declaratory judgment. The bottom line is there was a motion to dismiss, and the judge said that you can proceed in discovery.
That is correct. That is correct.
And that's something that hasn't been, that's sort of a breakthrough, I guess, in the banking industry, if you will. Is that fair?
There were 2 prior lawsuits over the same statutory question that were both blocked and did not reach the discovery stage. That is correct. And this custodial lawsuit did. That is correct.
Right. And the bottom line is, according to the public record in this decision, the judge, the governors, Board of Governors were claiming it was just a complete discretion of the Federal Reserve Bank of Kansas City. And the judge found that it's discoverable, and there's a plausible claim that the Fed, the Board of Governors, may have impacted the decision by the Kansas City Federal Reserve. I'm not asking you to comment. I'm just letting everybody know that that's what seems to go forward. I know you have a hard stop, and what I want people to know, if you survive this, if the judge agrees with the argument that's been made, we started the program where a statutory construction of shall. I don't know how you need to debate what shall means personally. I'm a very simple guy. I'm very simplistic in my analysis of cases, but from what I read of the applicable statute, they need to just give you a master account because you've satisfied all the requisites. And so again, you don't have to comment on that, but let me ask you, you're talking about choke point 2.0. I have to ask you this because right now, and especially in the XRP community, and I got DMs asking me this, so I'm gonna throw this at you and ask you if you know anything or if you have a comment or you don't. But Stephen Ayeroff has made a claim that when he got arrested, he was thrown in a van and was demanded by the FBI to give up whatever information he had on a litany of people from, and you were on that list, and there were other people on the list, journalists on the list, such as Naomi Brockwell, a client of mine, Vitalik Buterin and others. And were you aware of that, or do you know anything about it?
I was not. I did not know anything about it until all that came out. And when I started looking into it, what I spotted was there were a lot of names on that list, and the press picked and chose a few that might be the best known, but there were a lot of names on that list. I knew nothing about it.
Okay. And so you really don't know anything about it?
Nope.
Okay. Well, I'd be remiss not to bring it up. Listen, I want to thank you. When there is, I know as soon as there's more information that's public, I want everyone to know I'm going to put it on Crypto Law, and so that everyone can see it. We'll go through it because I believe there will be more public information coming out soon that once it's public, we could talk about, right?
Well, there is something called the administrative record. Anytime a federal agency is sued, there is something called an administrative record, and that was filed with the court. It's not on the docket yet. I don't know what the timing of that is, but there is a public version of that. It's under the APA, it's required that the administrative record be produced, and that you could go to the docket and verify that that was filed 4 weeks ago. And so when the court decides to make it public, then it presumably will become public. I have no idea when that is. So otherwise, the public information is the scheduling order, which is also publicly available, which is that the discovery in the case runs through mid-December, and there's a trial date scheduled for April.
Okay. And the only other thing, not only, but one of the other things that I had people hit me up, Caitlin, and this isn't about your case, so I'm not asking you to comment about your case, but are you overall optimistic about the future of crypto, which would include obviously the United States?
Yeah. I've said this before, and when you and I met at Consensus in Austin, we talked about this at the time.
We did.
It's kind of funny how this is all played out. The following statement, that I thought that the Biden administration was nuts to have some of these cases in the federal court system. I'm making a general statement, including the SEC cases, because they're opening up longstanding gray areas about the jurisdiction of federal agencies. For example, the Howey test in the SEC, right? That's been law for decades. And now it might be reopened by the federal courts, and the SEC might not get the answer that it wants. Okay. And so it's so, I guess, funny to me as I recognize that we're in the middle of it at Custodia as well, but it's funny that the Biden administration was that the crypto freak out that it had was so extreme that it went to this length, where it's now across multiple federal agencies in multiple federal court districts facing what I would call bet the farm type litigation, that if the agencies lose, their jurisdiction is changed permanently by the federal court system. And historically, as you know, because you've sued the SEC multiple times, the federal agencies don't like to be sued because they benefit from the gray area, and they constantly, frankly, have been expanding their jurisdiction, and nobody's really pushed back. And it's just funny that crypto became the thing that caused the true jurisdictional boundaries of some of these federal agencies to be examined by federal courts. And the implications, to your point, go well beyond just the actual companies involved in these cases, and go well beyond the crypto industry. They could have huge implications if, for example, an investment contract is no longer deemed to be a security by federal courts. that was a construct of the Supreme Court. That wasn't a construct of Congress. And so if what the court gave, the court might take back. And in the Monetary Control Act of 1980, that was a construct of Congress that got reinterpreted by a federal agency decades later, right? There's a lot of litigation outside of the financial services industry on that particular question. And I'll let you analyze that. When I sign off, this is going to be your analysis of the case alone. But
I know, but when we see the Supreme Court now revisiting precedent and basically talking about what, and the final thing I'd say with you is that your custodial's battle and lawsuit is bigger than crypto. It affects all fintech potentially companies moving forward. And so that's why I continue to try to draw attention to it. And thank you for so much. I'm going to bring you back when there's more public information that we can talk about. But thanks so much, Caitlin.
Thanks so much. Appreciate it, John. Best wishes to you.
Thank you. Okay, so listen, running up on time. I know a lot of people are waiting about this announcement on Friday, but let me just focus on this. There's not a coincidence. When I read that decision, and 27 months go by, it's supposed to take 5 to 7 days to get an answer on a master account, and all of a sudden, Custodia is denied membership by the board. And literally within hours, their master account is denied. If you don't think that's part of this choke point 2.0, it is. Let me just say that. You're being naive if you don't think. There's been an all-out assault. And I brought up the Steve Nayeroff thing just because, let's assume that what Nayeroff said is true. And it was in federal pleadings. So, most lawyers are not going to put something in a federal pleading if it's just made up out of the sky. Clearly, something has been set to kill crypto. They can't kill crypto, and they've adapted. But we keep winning in court. It's something I said a couple years ago, 2.5 years ago or more when I sued the SEC. I said, we can win in court if we keep doing it. I think Custodia is going to win. I thought Grayscale was going to win. I predicted it before they filed a lawsuit. And I said, whoever does will win. This administration does not have the law on its side, period. And we're going to win ultimately. Real excited Friday. That's all I can tell you. Got a few things got to line up, but if it does, it's going to be very exciting for me on a personal level. And I think also, hopefully for some of you out there. With that said, see you next week and stay tuned to Twitter. Okay, see you soon.